Our next panel is What Comes Next. Our panelists will be Professor Karina Barrett-Lane, Rob Dunham, Carol Steicher, and moderating the panel will be Megan Shapiro. Megan Shapiro is a capital trial and appellate litigator, a graduate of the University of Texas School of Law's Capital Punishment Center. She clerked for the Honorable Leonie M. Brinkema, U.S. District Court for the Eastern District of Virginia, and has had the further honors of serving as Deputy Capital Defender for Northern Virginia, staff attorney at the Louisiana Capital Assistance Center, resource counsel with the Texas Habeas Assistance and Training Project, and senior public defender for the Virginia Indigent Defense Commission's appellate cohort. Megan has been a board member of Virginians for Alternatives to the Death Penalty, a visiting professor at the College of William and Mary, and founder of the Friends Fund, a charitable organization serving formerly capitally accused persons now incarcerated in Virginia. She has been published in The Virginia Lawyer, the American Journal of Criminal Law, How Can You Represent Those People, and Defending a Federal Criminal Case. Now I'm going to turn it over to Megan. Thank you.
Thanks, Claire. Now, it's my great honor to introduce our amazing panel. Joining us to enlighten us all, we have today Robert Dunham, the Executive Director of the Death Penalty Information Center and a nationally recognized expert on the death penalty. Before moving to run DPIC in March of 2015, Rob was one of the leading capital appellate lawyers in Pennsylvania, arguing on behalf of that Commonwealth's death row prisoners in its state and federal courts and in the US Supreme Court. Rob previously served as executive director of the former Pennsylvania Capital Case Resource Center, director of training of the Capital Habeas Unit of the Philadelphia Federal Public Defender's Office, and as an assistant federal defender in the Harrisburg Federal Defender's Capital Habeas Unit. He taught death penalty law at Villanova Law School for 11 years and has served on the steering committee of the American Bar Association's Death Penalty Representation Project, as well as on the board of directors of the Pennsylvania Innocence Project and the Pennsylvania Association of Criminal Defense Lawyers. We're also joined by Professor Karina Barrett-Lane, who is the S.D. Roberts and Sandra Moore Professor of Law at the University of Richmond Law School, where she teaches criminal procedure, evidence, and a course on the death penalty. Professor Lane is a constitutional law scholar who writes about the influence of extra legal norms on Supreme Court decision-making, and also a death penalty scholar who is currently writing a book on lethal injection. Her scholarship has been published in the top law reviews in the country, including Stanford Law Review, University of Pennsylvania Law Review, and many more. Professor Lane graduated summa cum laude from the College of William and Mary and received her JD from the University of Virginia, where she was elected to the Order of the Coif. She clerked on the 10th Circuit and then prosecuted for 3 years, which we'll forgive her for, before entering the academy in 2001. Professor Lane is a recipient of the University of Richmond's Distinguished Educator Award and is also a former sergeant in the United States Army. And last but not least, we have Professor Carol Steicher. She's the Henry J. Friendly Professor of Law at Harvard Law School, where she serves as the Dean's Special Advisor for Public Service. She also served as faculty co-director of the Harvard Criminal Justice Policy Program from 2015 to 2020. And Professor Steicher specializes in the broad field of criminal justice, where her work ranges from substantive criminal law to criminal procedure to institutional design, with a special focus on capital punishment. Her most recent books are Comparative Capital Punishment, co-edited with Jordan Steicher, and Courting Death, the Supreme Court and Capital Punishment, co-authored with Jordan Steicher. Professor Steicher is a graduate of Harvard Law School, where she served as president of the Harvard Law Review as only the second woman to hold that position in its then 99-year history. After clerking for Judge J. Skelly Wright of the DC Circuit Court of Appeals, as well as Justice Thurgood Marshall of the United States Supreme Court, she worked as a staff attorney at the Public Defender Service for the District of Columbia, representing indigent defendants at all stages of the criminal process. In addition to her scholarly work, Professor Steicher has done pro bono work for indigent criminal defendants, including in death penalty cases in the United States Supreme Court. And she was appointed to the board of the Committee for Public Counsel Services, the statewide public defender for the Commonwealth of Massachusetts. She has served as a consultant and an expert witness on issues of criminal justice and capital punishment for nonprofit organizations, and has testified before Congress and state legislatures. And I think I can speak for everybody attending that we can't wait to hear what you all have to say. So with that, I will mute myself and hand this over to Carol to start us out. Thank you so much.
Thank you so much, Megan, for your kind introduction and for moderating this terrific panel. And thank you to Claire Welsh and to all the students from the Journal of Civil Rights and Social Justice for putting together this really terrific conference. I'm sorry that my brother Jordan Steicher can't join us today. He had hoped to, but is unable to, but I will try to carry our joint load solo today. And I'm also very sorry to be on the panel that is standing between all of you and Steve Bright. That's like worse even than being the panel just before lunch. So we'll try to keep it interesting. So let me begin. We're talking about, what comes next. And in thinking about what comes next, I want to recognize that we are in a new moment for the American death penalty. So 25 years ago, in the late 1990s, the death penalty seemed like a very secure practice, both on the ground and legally. The United States Supreme Court seemed pretty content not to interfere very much with what states wanted to do. And in the 1990s, we saw both the modern era peak of sentencing in 1996 with more than 300 new sentences that year, and the modern era peak of executions in 1999 with 98 executions that year. Anyone thinking about the death penalty at that time would have not seen clouds on the horizon, but for the death penalty. But then, starting in the turn of the millennium, the bottom fell out. And for the past 20 years, we've seen a dramatic decline of the death penalty on the ground. However you want to count, whether you count state repeals like Virginia, which we just heard about, gubernatorial moratoria, sentencing rates, execution rates, public opinion polls, there's just been a massive fall off. What Brandon Garrett called the Great American Death Penalty Decline over the past 20 years. And I would say that for the first 10 or 15 years of that period, the Supreme Court was also kind of heading in that direction. A very conservative court, with Chief Justice John Roberts taking over in that period. You would not expect this to be a court that, was going to do much to curtail the American death penalty, and yet it did. We saw the huge flowering of the court's proportionality jurisprudence. 15 years previously, the court had said no problem with executing people with intellectual disability or executing juvenile offenders. But with Atkins and then Simmons and then Kennedy versus Louisiana, where the court shut down state efforts to make aggravated child rape death eligible, the court really bulked up its proportionality jurisprudence and even started using it in the JLWOP context. And similarly, the court's Sixth Amendment jurisprudence and its rulings on effective assistance of counsel in Williams versus Taylor, Wiggins versus Smith, Rompia versus Baird, the court in 3 AEDPA habeas cases reversed capital sentences on Sixth Amendment effective assistance of grounds, and gave a nod in each of those cases to the ABA standards for capital representation. The court has since walked that back, but still, in each of those contexts, the court was looking to what was happening on the ground in the proportionality context, looking to state legislative enactments and then constitutionalizing them, and looking to changing norms of capital representation and then constitutionalizing those. So there was this feedback loop between what was happening on the ground and the Supreme Court's capital jurisprudence in a way where these things seem to be moving in tandem. So much so that in 2015, when Breyer and Ginsburg on the court dissented in Glossop versus Gross and called for the court to consider the constitutionality of the American death penalty, full stop, many observers, Jordan and me included, thought this was the moment the court was going to constitutionally abolish the death penalty. And it wasn't just like hopeful liberals. Justice Scalia in 2015 said he thought, in a speech, he said he thought that there were 5 votes on the court to abolish the death penalty right then. And in fact, in quite possibly the worst publication timing ever, Jordan and I published our book, Courting Death, Supreme Court and Capital Punishment, in which we predicted that the court would, in the next 10 to 20 years, constitutionally abolish the death penalty. The publication date of our book, Monday, November 7th, 2016. So, that was the day before the 2016 presidential election. It probably wasn't until 9 o'clock that night that we even contemplated the possibility that there would, be a non-democratic president of the United States. But we were not at least alone in our wrong prediction about how that election would go and whether that would, Justice Scalia had died and Merrick Garland's nomination was hanging in the wings, and we just kind of assumed that this is going to happen. But the 2016 election of Donald Trump as our president demolished any thought of judicial abolition in the short term. Instead of Merrick Garland, Neil Gorsuch. And then Justice Kennedy retired and we got Kavanaugh. And then Justice Ginsburg died and we got Justice Barrett. So now we have a solid 6-member conservative majority on the court. And this new court has shown itself to be resolutely hostile to robust constitutional regulation of capital punishment. Just how hostile? Well, consider the opinion for the court by Justice Gorsuch in Bucklew versus Praiseth in 2019, rejecting Bucklew's claim that Missouri's lethal injection protocol would be a form of cruel and unusual torture as applied to him because of his underlying health condition that could cause him to essentially drown in his own blood were he to be executed as he was by lethal injection. Now, unlike previous opinions that basically rejected, the Supreme Court has never accepted a lethal injection challenge. And it's always basically said, look, we held that the death penalty is constitutional in Gregg versus Georgia, and therefore there has to be a constitutional way to carry it out. And, lethal injection doesn't look so bad. So there we go. That tends to be the normal, Bayes versus Reese, Glossop versus Gross kind of majority opinion in these cases. Gorsuch's opinion was different. Gorsuch relied on the view that the death penalty is essentially invulnerable to constitutional attack on originalist grounds. Death appears in the Constitution. So from 1789 or 1791, however you count, there's just no plausible constitutional challenge to the practice of capital punishment. And he wasn't the first to do that because Scalia, in a sort of quintessential type of Scalia way, had floated this idea in his concurrence in Glossop, responding to Breyer and Ginsburg's dissent calling for consideration of the death penalty under the court's Eighth Amendment jurisprudence. And Scalia had said, Scalia took direct aim not at just Breyer and Ginsburg, but at let's go way back at Trope versus Dulles, right? The original more than 50-year-old precedent that said the Eighth Amendment is not about originalism, it's about evolving standards of decency that mark the progress of a maturing society, that the Eighth Amendment is a living, changing proscription in the Constitution. And this is what Scalia said about Trope versus Dulles and evolving standards of decency. He said that opinion on evolving standards of decency is one that, quote, has caused more mischief to our jurisprudence, to our federal system, and to our society than any other that comes to mind. I don't know, like Dred Scott, Plessy versus Ferguson, Korematsu. You know, I can think of a few that maybe have caused more mischief to our society than evolving standards of decency, but it just shows the fact that Gorsuch was picking up that line, shows just how aggressively hostile the court is to where we had thought it was on the Eighth Amendment. The Trump executions next, you know, I'm not going to go into detail, but the court there was not content not to be the source of stays of executions. Instead, it aggressively lifted stays imposed by lower courts without opinion, without consideration, argument, without briefing or argument, without explanation, through the so-called shadow docket. And in one case, doing so, taking the unusual step of doing it through cert before judgment, like not even waiting for the lower federal court to make its decision. So that showed, you know, tremendous aggressive hostility toward challenges, at least to those federal executions, with, you know, a new election and then inauguration on the horizon. But most recently, the court has showed that that was not a blip. That was not something that was time limited or about the Trump federal executions, because just a few weeks ago, in considering the Matthew Reeves claim from Alabama, where Matthew Reeves claimed that his intellectual disability prevented him from choosing an alternative to lethal injection in Alabama, and was granted a stay by the 11th Circuit, the court once again, through its shadow docket, no briefing, no argument, no opinion, lifted that stay without comment. So just showing aggressive willingness to move executions along, not just by not stopping them, but by preventing any other courts from stopping them as well. So here's the new moment. You know, we have this newly hostile Supreme Court that is really does not have to worry about losing Kennedy. They don't even have to worry about losing the Chief Justice John Roberts, because they got, you know, enough votes that even if they lose one here and there, like actually they lost Barrett on that Alabama vote, but they don't, you know, one is losable at this moment. So the court, super hostile, super majority, but at the same time now, instead of the court and the practice on the ground kind of moving in tandem, they're diverging, because the court is newly hostile, but the diminution of the death penalty on the ground continues apace, as the experience in Virginia, you know, so well illustrates. And I was fascinated to hear in our last panel in more detail about that. And this is not going to be a momentary divergence. This new 6-member majority of the court is here for a while. Justice Clarence Thomas is the oldest member of the conservative majority, and he's 73, which honestly may sound old to some of you law students, but that's like a spring chicken on the Supreme Court. And similarly, the movement on the ground seems pretty solid to maintain or continue. In the paper that Jordan and I are writing, we identify at least 8. We're now debating about a 9th. I won't get, you know, I'm just going to say them and not get into them. Things that contributed to the decline of the death penalty over the last 20 years, and almost all of them seem very likely to hold steady or continue. So concerns about innocence, which obviously played a big role. We heard in the Virginia story, you know, that the registry of wrongfully convicted people just continues to grow, even with the availability of DNA evidence now. The institution of LWOP, problematic as it is firmly entrenched, and juries now really understand that life means life, and prosecutors can stand behind that in agreeing to deals for less than death, because LWOP's like pretty serious punishment. Improved lawyering, which we heard about in Virginia, and new institutions like public defenders, but also just improved norms of capital representation. Cost has not abated. It's just ridiculously expensive for states, and that's what actually I thought was going to be another reason put forward for why conservatives sometimes support abolition. Growing international isolation around the world, the death penalty is declining, and in the United States, our outlier states are even more outliers in the international scene. Lethal injection challenges, which I know Karina will talk about, and have really managed to gum up the works, even though the Supreme Court has remained resolutely hostile to those. In states, they have really managed to slow things down. And I don't see that changing as states continue to try to experiment and with new things that create new problems because they can't get sodium thiopental. So I'm sure we'll hear more about that from Karina. And what Jordan thinks, if he were here, what he would say is the most important one on our list is shifting demographics, like in cities. He said in Texas, Houston, Harris County, Houston, and to some extent Dallas County, were like the big epicenters for the Texas death penalty. But those are purple cities now, and they have progressive prosecutors, and the death penalty has just fallen off dramatically. And this is not just a Texas phenomenon, the purpling of the cities. And honestly, cities are the only ones who can afford the death penalty. So where the red rural parts of death penalty states may want to continue seeking death sentences, honestly, they can't really afford it. It's like the caviar of the criminal justice system. And so, that's going to continue. The one that might go the other way is, I think, one of the things that helped drive that initial diminution of the death penalty in the turn of the millennium was 9/11 and the displacement of fear of ordinary crime with fear of international terrorism. Because, we entered into a period of tremendously declining domestic homicide, murder rates, and a greater fear of unnamed terrorists. So those two things combined just made the death penalty feel less necessary as community protection. That one may be shifting back, but almost everything points to continued withering on the vine, even as the Supreme Court is chomping at the bit to let executions go forward. So what does that mean, this new period in which we have a divergence between what's happening on the ground and what's happening at the Supreme Court? One question is, will there be a new feedback loop? So I just discussed the feedback loop between diminution on the ground and the development of more robust proportionality and standards for counsel. Now that the Supreme Court is, totally semaphoring its hostility to regulating the death penalty, will there be a new feedback loop in death penalty states where they get more aggressive in what they're willing to do, knowing that there will be no federal regulation that will, yank their chain? So that's a question. And these are really questions because this is honestly, let me just say, speculation. This is a little bit less untethered. States that want to go forward with executions are going to be able to do it with less fear of being stayed and delayed than in prior years. So I think executions for states that want to do it, and as we've said, you need really a perfect storm of consistent, willingness, not just from prosecutors, but from governors and state judges to get an execution to happen, but they're not going to hit any resistance on the federal side. So I think we're going to see executions go forward in those states. And so death row is going to start to shrink. But death row is going to start to shrink. But as I've said, it's the hopper isn't going to get filled up with equivalent new sentences because of those purple cities and the high cost of the death penalty and the better lawyering and all of that. So we're going to see, I think, a shrinking of death row. What will that mean? I think that will mean a decline in the salience of the death penalty as a political issue. It will become even more geographically concentrated than it is now. And, you know, there will be, you know, after perhaps a spate of executions, there will be just fewer going forward. It'll be a shrinking practice. And as it shrinks, there'll be less sense. The less we have of it, the less strong the arguments are that it is a necessary practice, that we really need to have it, or that the norm would be, you know, a death sentence. Like when there are a lot of death sentences, prosecutors have a hard time telling victims' family, well, not for you. But when very few people are getting the death penalty, it's easier for prosecutors not to do it and to just, you know, make deals for life. And ultimately, I think death penalty advocacy and, you know, is going to turn away from federal litigation, concentrate on state litigation, and concentrate on front end advocacy in terms of legislative initiatives like, you know, that we saw were so successful in Virginia. So, you know, ultimately, our ultimate take, I'm going to wind up because I'm like over my time. Ultimately, our take is that we are entering a period of what we're calling in our paper, it may even be our title, we're arguing about that, abolition in waiting. That is, the circumstances on the ground will continue to make a case under the court's current Eighth Amendment doctrine for an eventual constitutional coup de grace, which we do think eventually still will happen, just not soon, maybe not in our lifetime. Our lifetimes, Jordan and mine, but maybe yours, in yours, Washington and Lee students, in your lifetimes. And so, you know, this court, no, but on the ground, you know, abolition in waiting, in hibernation, a good word to use in this cold New England winter. Thank you.
Thanks, Carol. We're going to now move to Karina. Karina?
Thanks. Carol, I love so much listening to you because, you know, I've been taking notes on my iPhone thinking like I have about 10 things. I don't even want to talk about my stuff anymore. I just want to be in conversation with you. So I'm looking forward to the conversation. Well, my 10 to 12, 15 minutes, whatever, will be spent talking about lethal injection litigation and its role in what's next. And, you know, at first glance, lethal injection litigation is an odd thing to think about when thinking about potential abolition. After all, these are people who are not challenging the state's right to execute them. All of that is over. Now we're just fighting about the details of the deed and how that will be done. And more to the point, lethal injection does nothing to stop death sentences. And we know from Carol and Jordan Steicher's work, among others, that the political payoff of the death penalty is way more in death sentences than it is in executions. So to the extent the death penalty is a highly symbolic issue, it's the idea of it that matters and the political message that it sends. Politicians don't necessarily need executions to get that political payoff. And indeed, it's possible that backed up executions may add to the political points that they are able to capitalize on because it gives them something to rail against. And so thinking about it that way, I was reminded in putting together these remarks of when I was first starting to get sucked into the black hole that is lethal injection. And a mentor said to me, well, if you're going to write on the death penalty, why not spend your time writing about something that matters? And so it was like race in the death penalty, or ineffective assistance of counsel, or executions of innocence and the severely mentally ill. Like somewhere anywhere else. And yet, here we are. Dick Dieter, who is the former executive director of DPIC before Rob, said back in 2008, lethal injection challenges have already held up more executions and for a longer period of time than any other issue. And that was in 2008. It's 1,000 times more true today. And one might respond, fine, so we're not executing, but we were never executing more than a sliver of the people on death row anyway. You just said that the death penalty is mostly symbolic, so why does it matter? Why does lethal injection matter? And I think there's an obvious answer. That's not where I'm going to spend the bulk of my time, but I might as well name it. And I think that obvious answer is sheer volume. You know, lethal injection is a potential claim for every condemned inmate, so it's not limited to the facts of the case. And that potential for litigation alone makes the death penalty more expensive, right? You're either executing, you're litigating to execute, or you're housing them for years. It takes a consumption of resources. It makes the state work harder to make its system work. And in that way, I think of it as like fistfuls of sand in the machinery of death. You know, the gears are grinding on, but they just get bogged down. And all of that is true. But in my moments, I'd like to spend my time on 3 impacts that receive, I think, less attention and maybe less obvious. The first is salience of the death penalty. So I think that our papers, Carol, are in conversation with each other. But you know, I'm a firm believer that lethal injection was designed so that people would not think about the death penalty. So they would not think about the fact that the state is actually killing people and the violence that is inherent in taking human life. You know, I think of like out of sight, out of mind. That's a plus for the executing state. And in this way, lethal injection litigation is the culmination of a long line of efforts to privatize executions when they become problematic, to minimize opposition to the death penalty by minimizing how much people think about it at all. But with lethal injection, the opposite has actually happened. And whether it's drama over the drugs or over botched executions or state malfeasance that ends in grand jury investigations and mass resignations, it's press. The death penalty is in the press because of lethal injection, and it's bad press. In this regard, I love the line from Political Magazine that was covering some of this and said, and I quote, "America is terrible at killing people legally." And I think that's exactly right. I think that just like hits it. And it's worth noting that this salience has had an impact in some unexpected ways. So for example, consider European abolitionism. Europe has been fiercely abolitionist for 60 years now. It's part of the EU human rights policy, but that discourse, that the notion that the most basic of human rights is not being killed by your own government, that just has not been part of the domestic discourse for reasons that Carol has written about in other work. You know, it's really hard to say that the death penalty violates a basic human right when the Supreme Court has said that's constitutional. I mean, that's just a part of the discourse that's largely been absent. And the fact that the United States is such an outlier on the death penalty has not really been part of the conversation. It's just that, you know, we're so big. We're the 1,000-pound gorilla in the room. So it's like, who cares what anybody else thinks? We're America. But, you know, and so, you know, the EU has done all this stuff. There's been conferences and speeches and various human rights instruments and diplomatic attempts, the refusal to extradite, amicus briefs to the United States Supreme Court. It's like they've done everything they can possibly think of, because European abolitionism is not just about abolishing the death penalty in Europe, it's worldwide abolitionism. They have stated that, they've explicitly said, this is one of our core values, this is what we're trying to do. So they've been trying to break in to this very insular United States exceptionalism on the death penalty. And, you know, the death penalty is just rolled on with most Americans completely oblivious to the fact that European opposition ever even existed. But now we can't get the drugs. And that's brought a slew of attention from the popular press, including headlines naming European anti-death penalty sentiment as the reason for the shortage. Everything that has happened with lethal injection starts there. Attempts to get domestic manufacturers to put end user agreements so that they're not selling the drugs, the turn to compounding pharmacies, the experiments, all of that started in a ground zero moment when Europe, completely shut off our access to the drugs, and so this has been part of the discourse. As one article in the press put it, let's remember why we're here. Like, you can't understand that we can't get the drugs without understanding how this started, which was European abolitionism. Now, who knows how much any of this has made a difference? And in fact, one could say that European abolitionism is actually fueling a backlash, right? This is America. We're proud to be different. But my point here is that media attention, that salience, has inserted European abolitionism and the reason why into the domestic discourse in a way that it was not there at all before. And my larger point is that lethal injection was supposed to be a way to go silently in the night. Now it is loud, it's causing controversy at every turn, and all too often it is revealing shocking revelations of the way that the state, executing state works. That's my second point, so I'll just move there and just say, it's not just bad publicity, but it is shocking revelations that raise their own questions about the propriety of the executing state. So I'm just going to give you 3 examples of this, but I promise you there's more where this came from. Here's the first, Harris Pharma. So states could not get the drugs from the European suppliers, so they went to India, specifically a company called Harris Pharma. But Harris Pharma was just a guy named Chris Harris, who, as it turns out, was an independent contractor that misappropriated some drugs from a major manufacturer in Europe. He told them, I'd like to take this sodium thiopental. I'm going to go to Africa. I'm going to develop your market there. So they gave him a bunch of samples. But what did he do? Did he go to Africa? No. He sold them to Nebraska. Now, all of this came out. It was proven. The major drug manufacturer demanded its drugs back, said he stole it from us. He misappropriated our drugs. We want our drugs back. Nebraska was like, no. It's ours. There was litigation over it, and the drugs expire before they're able to be used. But in the wake of that, 2 more states, Texas and Arizona, they're like, oh, we didn't know about Harris Pharma, so let's go to Harris Pharma. So they end up contracting with Chris Harris for some of his drugs, which they know are misappropriated. And there's a bunch of litigation. I think, it sort of settled itself. The states didn't get the drugs, but anyway, so that starts litigation, and that draws more media attention. And so some investigative reporters go over to India to check out this Harris Pharma, and they find out it's just this guy named Chris Harris. Oh, and by the way, the address that he used for his manufacturing plant, that's his flat, that's his apartment. It has no manufacturing equipment in it. He couldn't be making these drugs if he wanted. He's just taking other people's drugs, slapping his label on it. Oh, and one other thing, he left without paying his rent for 6 months. So he's on the lam, clearly a black market supplier, and the states are demanding, litigating, give us back our drugs. That's just one example. A second example, more quickly now, another state, Missouri, was buying drugs from a compounding pharmacy. So investigative journalism ends up figuring out what the compounding pharmacy is. Turns out they had over 1,800 safety violations. And yet Missouri's like, no, we really want to use this pharmacy. The same state, Missouri, had used a doctor to conduct the executions. Most states don't, but this one did. He had been sued for medical malpractice over 20 times. He had his hospital privileges revoked by 2 hospitals. And it turned out that Missouri gave him full reins, not only to execute, but to revise its protocol in any way he saw fit. So all of this came out in lethal injection litigation, and he's under deposition, and they're asking him how much he's using. And he says, I think it was this, but I can't remember because I didn't write it down. And also I'm dyslexic, so sometimes I mix up the numbers. True story. And again, Missouri is insisting to keep using him. And so you're seeing all of the ugly underbelly of the death penalty. And for this audience, I know these that you're all saying, yeah, I know how ugly it is. And I'm thinking, it's so ugly everywhere else. Just imagine how bad it is at the end of the process, because it's just really bad. And so all of this is showing how haphazard the protocols are. By the way, Oklahoma's midazolam protocol, it was chosen by 2 lawyers surfing the internet. True story. True story. It chose misappropriated drugs, illegal drugs, shady deals with shadow suppliers, and secrecy statutes to cover all of it. All this is to say that states have sacrificed not only the integrity of their executions, but also important values: government transparency, regulatory compliance, respect for the rule of law, and the utmost care in the most solemn of its duties. And then third and finally, lethal injection litigation and lethal injection itself has brought new allies in the death penalty fight, or in the fight against the death penalty. So first, it's weaponized European abolitionists. I can't stress this enough. As I said, the EU has tried to do every single thing it could think of in furtherance of its commitment to worldwide abolition. And all of those efforts had one thing in common: they were spectacularly ineffective. And then came lethal injection. And the EU literally stumbled upon its export controls when a domestic pharmaceutical company, that's Hospira, had an aging North Carolina plant that had a bad inspection. And they were like, it's going to cost too much money for us to just fix this plant. Let's just go where the rest of big pharma is. Let's go over to Europe. So they moved to Italy. And then Italy's like, oh, wait, you're selling to DOCs. We're not going to allow you to do that. And then it occurred to them, oh my gosh, we should put export controls on this. And so they do. And, you could see Europe over there going, oh, wait, all we had to do to disrupt the American death penalty, which we've been trying to do for like half a century, is just stop selling them our drugs. Okay. So second, it's brought drug suppliers and big pharma and its distributors into the fight. So at first, it is certainly true that abolition groups were nipping at big pharma's heels, using bad publicity to force big pharma to tighten up its slack distribution systems that were allowing the departments of correction to get the drugs. But once they did that, states responded by breaking those contracts and getting those drugs sales surreptitiously. So for example, Texas started by falsifying a prescription and using the address on a non-existent prison that wasn't even in existence anymore. Pharmacy figured it out and would refuse to sell. Louisiana obtained drugs for lethal injection by telling a local hospital that it was for a patient. Oklahoma has taken a slightly different approach, using its Department of Mental Health and Addiction to buy its lethal injection drugs. And it did this from 2017 to 2019 when it was all discovered, because it knew that manufacturers had these end user agreements to prevent their use in lethal injection. So here's a quote from an actual email that was sent from the Ohio Department of Corrections to the Department of Mental Health and Addiction. Quote, "When you call them to see if they will sell to us, make sure you say we're the Department of Mental Health. Do not mention anything about corrections in the phone call or what we are going to use the drugs for." Over the last several years, over half a dozen other states have also managed to buy drugs for lethal injection from pharmaceutical companies that have refused to sell drugs for lethal injection, using pretense and deception to get around contractual conditions on the sales. For their part, drug manufacturers are done with these cat and mouse games that have plagued their relationships with executing states. Now they are suing. And then finally, very briefly, two other groups that have now gotten into the fray. One is good government groups. So we're seeing all kinds of interest from good government groups. Why? Because as lethal injection has become more problematic, states have held on to the information tighter, passed all these secrecy statutes. And so now good government groups are getting into the fray. And then finally, last but not least, the medical profession. So the medical profession has more or less stayed out of it, except lethal injection has dragged them in too. Lethal injection, whether it uses doctors or not, uses the equipment of the medical profession. And within the medical profession, there's a huge discourse about how lethal injection corrupts the medical profession. It dirties their white coats and all that they represent, and it exploits the medical profession, the medical profession's regard for humanity, and uses it for the state's purposes. So of course, every single medical organization in the United States has issued statements telling its members to stay out. And importantly, the American Board of Anesthesiologists has gone further yet, saying, we will take your board membership, which, by the way, you need for hospital privileges if we find that you are assisting in any way, including advising executing states. So all of that is to say, the Supreme Court, as Carol has said, has done all it can to support lethal injection. Truly, anything goes. But despite the Supreme Court's refusal to rein in the risky behavior of executing states, lethal injection has set in motion developments that have put their own brakes on the execution process, all while bringing unwanted attention to the death penalty, exposing ugliness, and bringing new allies into the fight. It's not clear how this story will end, but I can tell you that states cannot fix what ails lethal injection. I'm at the tail end of a book on this. And so far, to the extent they've figured that out, they've been moving to other methods largely discarded because they themselves brought bad publicity to the death penalty. And at least some states were worried that that would cause an erosion of death penalty support. So all of that is to say that it seems clear now that while lethal injection is at the back end of the death penalty story, it will clearly have an impact on what happens next. Thank you.
Thank you, Karina. Rob, to you.
Well, thank you very much. And first of all, thank you, Claire, and everybody who has put this conference together. It's terrific. Some of what you hear from me, in fact, a significant amount of what you hear from me, you may have heard in different contexts over the last 2 days. But I want to tell you what I think the story of the continuing decline of capital punishment is about. And I would say it in 2 words: corrosion and erosion. The corrosion of capital punishment is the degradation of the brand, if you will. And it's demonstrated by all the things states and federal governments have been doing that show that states and governments are not trustworthy to carry out the death penalty. They impose it arbitrarily. They carry it out unlawfully. They engage in practices that if you or I did them would put us in jail. And the more we hear about these things, the more the public hears about these things, the less they support capital punishment. The death penalty opposition is a coalition. There's not a single argument you can raise that will persuade everybody. They don't even attract a majority, but different arguments attract different groups. And one of the key things in abolition is getting to that 51%. The way you get that 51% is you take, as we saw in Virginia, as we saw in a number of other states, New Hampshire, you take people who are pro-life and you show them why pro-life is anti-death penalty. You take people who are in favor of civil rights and you show how the death penalty is racially discriminatory and economically discriminatory. And you take people who are good government people and you say, is this really what you think the government should be doing? You take conservatives who believe in cost effectiveness and you show the death penalty is costly and ineffective. And you take people who are libertarian or otherwise distrustful of government. If you don't trust the government to fix potholes, if you don't trust the government to regulate shoelaces, how can you trust them to take a life? And each time we see the kinds of things that Karina has talked about, the kinds of things that you've heard over the last couple of days, that makes it so the government is less trustworthy. And that brings over conservatives. And that, in many states, one by one, is enough to get over the top for abolition. I'm going to tell you a bunch of things that initially we've seen in the context of the United States Supreme Court challenges to capital punishment. And I would say that we are not going to see the US Supreme Court abolish the death penalty, but we are seeing state courts using the same kinds of reasoning that Justice Breyer was talking about, that the court has applied in the evolving standards context to get rid of the death penalty in their states. And there are also arguments that are being used by abolitionists to persuade lawmakers that the time has come and gone for capital punishment. If we want to go into the future, here's the direction that the river is flowing. So we all know this. States with a death penalty, now it's 27. It had been close to 40. States without the death penalty, 23 in the District of Columbia. Direction of change, since 2007, 11 states have repealed the death penalty or declared it unconstitutional, and Virginia opened the door to the South. But take a look at this map, because it tells you two things that I think are really important. There is now a death penalty free zone that runs from the northern border of Maine, the Canadian border of Maine, all the way to Virginia, Virginia's border with Tennessee at the Cumberland Gap, 1,300 miles where there is no death penalty. If you want to, when I talk to folks from Europe, what I say is, you could drive from the Channel in London and go all the way to Romania without entering a state that has the death penalty. In the Western United States, on the Pacific coast, it is an execution-free zone. You can start from Alaska and go down to the border with Mexico and not have a state that allows executions. Alaska, no death penalty. Washington, no death penalty. Oregon, a moratorium on executions and a legislative amendment to its capital punishment statute that makes it virtually impossible for a crime to qualify as capital punishment. California, the largest death row in the Western Hemisphere. California has a moratorium on executions and just had a recommendation from a legislatively formed committee on reforming the penal code saying the state should abolish the death penalty. And what we are seeing is that the death penalty is becoming increasingly geographically isolated. It always was, but it's even more so. And when we look at practice, Amnesty International defines abolition as either not having a death penalty or not carrying it out in a decade. Well, 36 states now either no longer have the death penalty or haven't executed anybody during that period. That is close to 3/4 of the United States. South Carolina, which is trying to bring back executions and doing so in very peculiar ways. They scheduled executions a couple of times without a method to carry it out. And then because they didn't have the drugs, they decided that they were going to authorize it by electric chair and violated their own requirements that they also make the firing squad available. Even talking about frying people to death or blowing them away is bad for South Carolina and everybody else, because polls show that the United States, still a majority of folks think that lethal injection is okay, but the states can't do it and they can't do it right. But they think that every other method of execution is cruel. So it's not just what legislators have available to them, it's what their constituents can stomach. And the more, as Karina said, the more that becomes an issue, the harder and harder it is for the death penalty to move forward. Here's the long term. You can see the numbers. Death row is declining every year for the last 20 years, at the same time that executions are declining. That means what's happening is that we're not executing our way out of capital punishment. Virginia did. But through most of the country, what's happening is it's attrition. Cases are being overturned. New death sentences are not being imposed in those cases. Fewer new death sentences are being imposed, period. People are dying on death row. People are being removed from death row. 20 straight years of decline, a 34% decline in the size of death row at the same time that executions are reaching record lows. Executions are the lowest since 1988. Death sentences are at historic lows. Now, the pandemic has something to do with that. And that's why I'll talk about 50 death sentences a year as sort of the guidepost for the generational decline. But the last 2 years, we've had 18. And if you add those two together, it's 36. And the lowest in any year since capital punishment came back. before the pandemic was 43 in the first year after the Supreme Court declared the death penalty unconstitutional. And if you see the graph in the right-hand corner, we're down below that on a regular basis now. So the death penalty is being cut off at the entrance point. Now, we all know the famous line, right? The death penalty is arbitrary, like being struck by lightning is arbitrary. Today, it is just as arbitrary, if not more so. And that's something that with a different Supreme Court would have resulted, I believe, in its abolition. But with this Supreme Court, that doesn't matter. They do not believe in the evolving standards. As Carol said, they don't even believe in trop dullis. But that doesn't mean that the states don't. And so we're seeing the arguments being advanced at the state level and getting traction. And they did in Connecticut, and they did in Washington State, and they did in Delaware. Here's the facts that are stunning when we're talking about the arbitrariness. If it's just a handful of people out of a lot of people who got the death penalty, well, think of this. In the past 10 years, even though the US population has increased by 120 million people since Furman was decided, and there are much more murders, even with low murder rates, we're having fewer and fewer people sentenced to death. If it was arbitrary, like being struck by lightning, I don't know what this means. You have to be struck twice? The death penalty is statistically more arbitrary than it was at the time of Furman. And when we're looking at this, here's a graph on the left of how many death sentences were imposed over each 10-year period. We are below the death sentencing rates, just in pure numbers, before Furman, despite the increase in population, despite the increase in the number of death sentences overall. And when we're looking at where death sentences are being imposed now, we are 75% below the death sentencing rate in the decade before Furman. It's stunning. It's a major disappearance and erosion of capital punishment. Public opinion also shows that we are at historically low levels in support for capital punishment. The Gallup poll has death penalty support at the lowest it's been since just before the US Supreme Court declared the death penalty unconstitutional in Furman versus Georgia. A record low percentage of Americans now regard the death penalty as being morally acceptable. For the first time in Gallup's poll, they found that a majority prefer alternatives to the death penalty. And this is more the policy question as opposed to the abstract, do you support or oppose capital punishment? And we're talking about 60% who prefer life alternatives to capital punishment. That is a significant number. And a polling index that was put together by Professor Frank Baumgartner at the University of North Carolina took a look at more than 500 public opinion polls on capital punishment over the course of 75 years, and through an algorithm that I don't pretend to understand, was able to ascertain that overall the level of support for capital punishment is lower than it has been at any time since 1965. So we are seeing significant erosion in support for capital punishment. We're also seeing counties opting out. In 2013, we did a report, the 2% death penalty, that showed that half of death row came from less than 2% of all the counties in the United States. We've updated that, and we will have a Furman at 50 report in July, in the end of June, and it will show that half of death row is produced by 1.2% of the counties in the United States, a much more constricted group than it was before. And when we looked at the counties, the 30 that had the most death sentences, most people on death row, the 1% of counties, we have now found that since 2013, when we did this report, 1/3 of the prosecutors in the most prolific death sentencing counties in the United States are now reformed prosecutors. And that means those who disproportionately produce death sentences won't be producing them anymore, or at least not anything close to those numbers. Now, is this chicken and the egg? I use Philadelphia as an example. You can see on this graph a plummeting of the use of the death penalty in Philadelphia. And it even began during America's deadliest DA's tenure, Lynn Abraham. But it just dropped off, and because of disuse, because of distrust, because of evidence of systemic racial discrimination in the use of the death penalty and systemic prosecutorial misconduct, it became an issue, and now it's become a non-issue. There is no more death penalty in Philadelphia, and this death penalty wheel that you see, this was a couple of years ago. It is even greener now, and the green, I chose green because that indicated to me money thrown out the window, or as Larry Krasner, the Philadelphia DA, said, the death penalty is like lighting taxpayer money on fire. Those are all the cases that the death penalty was overturned and was not reimposed afterwards. This is before Larry Krasner took office. There has been one execution in Philadelphia. There have been multiple exonerations, and the green keeps growing. The financial waste keeps growing. What we see is, and this is the case in every state that has the death penalty, and it's not just the national trend, that arbitrary factors are driving the death penalty. Race, place, and time. They disproportionately account for which cases end up on death row, and not one of them is a legitimate basis for employing the death penalty. Race, the death penalty is America's original sin. Well, slavery is America's original sin, and the death penalty is an outgrowth of slavery, lynching, and Jim Crow. And if you want to know where it happens, look for where the lynchings happen. That is where executions disproportionately happen in the United States. And we know that there is white preference. You are much more likely to get in the death penalty box if your victim is white. Now take a look at this map and the next one, because we all know from all the data that people who kill other people tend to kill people like them. The race disparities, it's not black on white, it's white on white. It's black on black, it's Latino on Latino. Well, take a look at the next map here, because here we're going from race of victim. Whoops. It's not there, race of defendant. I'm sorry, there it is. Okay, so there is the race of victim. There is the race of defendant. It is disproportionately people of color. And we know that it makes a difference. What you look like makes a difference. And there's an interplay of the two. In Philadelphia, the study showed that if you had classically African-American features, you had double the likelihood of being sentenced to death than if you didn't, but only in one category of victims, white victims. If your victim was African-American, it didn't make a difference. And the data, this is from David Baldus, but this graph shows up everywhere you have capital punishment. No matter how terrible a murder is, no matter how severe the murder is, at all levels, there's the same combination of defendant and victim that is most likely to produce a death sentence. That is a black defendant and a white victim. And if you're black, you're more likely to get the death penalty with a black victim too than if you're white. And if you are a victim, well, if you are a white victim, it's more likely to produce a death penalty. If you are black, it is less likely to produce a death penalty. Whatever your race, you're more likely to be executed if your victim is white. So place, the 2% study, our review shows that now 1.2% of all US counties account for everyone on death row in the United States. More than 80% of the counties have never executed anybody. More than 80% of the counties don't have anybody on death row. And as death row shrinks, it is shrinking at the county level too. And place, more than 80%, 82% of all the executions the past half century have been in the South. It's also not just geographically isolated, it is isolated within particular counties within the killing states. Just 5 counties in the entire United States account for 20% of all the executions in the US in the past half century. And three of them, four of them up top are Texas and then Oklahoma County. And Oklahoma County has three of the people who are scheduled for execution in Oklahoma's execution spree. When that spree is finished, Oklahoma County will be tied for third with the most executions in the last half century. We've seen that the death penalty is really declining, and so there's a function of time. Time is a proxy for many things. It's a proxy for declining murder rates. It's a proxy for declining death penalty support. It's a proxy for what the public knows now that it didn't know in the 1990s. It's a proxy for systemic improvements like the creation of institutional capital defenders. And all of that changes the dynamics of a trial that is being performed now versus a trial that took place at the height of the death penalty in the 1990s. But one of the studies that Frank Baumgartner shows the amazing difference that time makes. A murder that was tried in the 1990s is 5 times more likely to have resulted in a death sentence than a similar murder if it were tried in the last decade. Time has nothing to do with the moral culpability of a defendant. Race has nothing to do with the moral culpability of the defendant. Place has nothing to do with the moral culpability of the defendant, and they are the driving factors in the US death penalty. Now, mounting statistical evidence also tells us that the death penalty system is arbitrary in that it doesn't do what it is supposed to do. We assume that what's supposed to do is reach a capital outcome and execute the right person. It's supposed to make people safer. We looked at 30 years of FBI data. We only chose 30 because that's how far back their data went on police safety. I don't have time to go through all this, but the slides will be available. Ultimately, what we found is that death penalty does not deter. It does not make police safer either. Murder rates are higher in states that have the death penalty, and that's consistently so over the course of the 30 years. And what we see is that, just look at it. The graph, the yellow is the death penalty states, the blue are the states that never had the death penalty during that period. It is consistently higher in states that have the death penalty. And when we aggregated the states, because we didn't want Texas to skew the death penalty numbers and Rhode Island to skew the non-death penalty numbers, you see that the death penalty states are disproportionately at the bottom of this graph, where there are higher murder rates. The non-death penalty states are at the top, and the death penalty states that are at the top with the least rates of murder are the states that haven't carried it out. Police officers, it's the same thing. Police officers are murdered at much higher rates in states that have the death penalty than in states that don't. It doesn't make them safer. The patterns here, it's much more erratic because the numbers are so low so that you can have much more spikes, but the pattern is still the same. It's higher in states with the death penalty than states that don't. The most interesting thing is the green line here, the transitional states that got rid of capital punishment at some time during the study had the lowest murder rates. Not that it doesn't make any sense at all that you'd have the lowest rates of police killings if you've just abolished the death penalty. That's completely counterintuitive. What it tells us is that there is a disproportionate role, political role, that police killings have in the death penalty debate. And once that's taken out of the picture and the debate becomes about whether the death penalty works, that's when states are much more likely to abolish. But what we see here again is the states that don't have the death penalty, or most recently got rid of the death penalty, or don't enforce the death penalty through executions, are the ones that police are safest in. Now, does that mean that getting rid of the death penalty makes police safer? No, that's ridiculous. The death penalty has nothing to do with police safety. It does not deter. It doesn't do what it is supposed to do. That is the justification the Supreme Court said could be used for saying that there is a valid penological reason to have capital punishment. It is divorced entirely from reality. And does the death penalty reach the correct substantive outcomes? Well, there are a couple of factors, important factors: innocence, delays, reversals, wrongful executions. The answer to this question appears to be no. The single most likely outcome of a death penalty case, once a conviction is reached and death sentence is imposed, is that the conviction or death sentence will be overturned and the person will not be resentenced to death. Frank Baumgartner looked at the Bureau of Justice Statistics data for 8,000 cases. We are finishing a death row census, and we will have looked at more than 9,700 death sentences that are imposed. And it is still true. It is even more disproportionate than what Frank found. The single most likely outcome is the death penalty is overturned and not reimposed. The second most likely outcome is that you're still on death row and the case is still in the system. Only about 1 in 6 of the cases ultimately results in executions. The second most likely outcome is still on death row, and a question that Justice Breyer raised as a result of that is, what's the point? What deterrent value could there possibly be, even if the data showed that there could be a deterrent, if, as the fact is now, half of everyone on death row was sentenced to death more than 2 decades ago? And innocence. There are now 186 documented cases, and I still believe there are others out there that we haven't found, of people who are wrongly convicted, wrongly sent to death row, innocent and exonerated. 186 since 1973. And if we look at those numbers, that is 1 person exonerated from death row for every 8.3 people who have been executed. Let's make this a plane. And let's have this, the 8.3, the plane landing where it's supposed to land. If 1 plane crashed, for every 8.3 planes that landed where they were supposed to, you know that we'd be doing something about it. We would probably be either revamping or ending the aviation system. And think of the first slide with reliability. The single most likely outcome is the death sentence is overturned and is not reimposed. Let's think of that in terms of trains. If the most likely outcome of your train travel was that you ended up in the wrong place, I think we'd be doing something about that. The scary evidence on innocence is this is not accidental. The debate on the death penalty and trustworthiness, the debate on death penalty and whether it's, well, you know, there are accidents and we can tolerate a certain level of killing innocent people because, you know, we do the best we can. The fact of the matter is that the primary reason that people are wrongfully convicted and wrongfully sentenced to die is official misconduct. And it is official misconduct most of the time in conjunction with false testimony. These are not accidents. And you talk about the corrosion and erosion of capital punishment. We can fix evidentiary rules, maybe. We can get better science, maybe. We can get maybe better eyewitness identifications, but you can't eliminate human nature and corruption. And so long as that remains a factor with capital punishment, there are always going to be innocent people who are getting wrongfully convicted and wrongfully sentenced to death. And it is now undeniable that some of them have been executed, and we won't know ever who some of them are. It's also not just that people don't get executed, because a lot of people still do. It's 1,542. But the people who get executed shouldn't be getting executed if you apply the law. A new study shows, and you heard from John and Sherry earlier, it's their study. We call it the dead right or right too soon study. At least 1 in 7 of the people who've been executed in the United States were put to death despite having legal claims in their case that would make them either ineligible for the death penalty altogether or would have established that their death sentence was unconstitutional. 1 in 7, almost 15%, an average of 5 people per year being unconstitutionally executed since executions resumed in 1977. The worst offenders are two of the states that carry out the death penalty the most. Texas, 108 legally wrongful executions, 1 out of every 5. Florida, 36 legally wrongful executions, 1 out of every 2.75 executions. That is a level of systemic unreliableness that is completely intolerable. And there are other things that corrupt the legal process, the appellate review process. Volunteers, 1 in 10 people who's been executed in the United States voluntarily gave up their rights. And so we didn't have society's interests in the just adjudication of capital cases vindicated. These are cases where there are significant issues, mainly issues of mental illness and deficient representation that never get presented anywhere. And these people who volunteer and are permitted to waive their rights and commit suicide by state grossly skew the death penalty process. They were 4 of the first 5 people executed after Gregg versus Georgia. They were the first executed in 15 states and the federal government after the death penalty came back. In 4 states, they're the only people who were executed. And 6 times their insistence on being executed is what ended hiatuses and executions, hiatuses that ranged from 5 years to 21 years. And as Scott Dozier's attempt at state-assisted suicide, failed attempt, showed, they force states who sometimes don't want to carry out executions into engaging in drastic measures to try to obtain drugs. In Scott Dozier's case, Nevada got their drugs under false pretenses, had them sent 200 miles from the prison to a fake location, and a court ruled that it was an invalid purchase because, in the court's words, the drugs were obtained by subterfuge. Scott Dozier then committed suicide in jail after he was unable to get the state to kill him. And there is a lack of meaningful substantive review that is made worse by the current practices of the United States Supreme Court. Harris County has put more people to death than any other county in the United States, more than any other, well, it's not other, more than any state except for Texas itself. And what we have found is in 96% of the cases in which there were contested issues of fact, Harris County trial judges adopted the pleadings of the Harris County DA's office verbatim. It is as if the Harris County prosecutors were the ventriloquist, the state court judges were the dummy, and the federal court was the audience pretending not to see its lips move. That has never been due process. That has never been fair process, but that is how people get executed in Houston, Texas. And of course, they have to go through the Fifth Circuit, which covers the rest of Texas. And since the Congress amended the habeas statute to require deference to state court fact findings, to require deference to state court legal determinations, and to allow relief only when there is I would say, misapplication of clearly established United States Supreme Court law. When you take a look at all the death penalty cases or sentences imposed since the year 2000 that have gone through the Fifth Circuit, and there are more than 150 of them, relief has been granted only once. That is hardly meaningful substantive review. Carol,
I'd like to transition to a discussion once you are at a stopping point, and I can.
Well, actually, this actually is the stopping point.
Okay.
With the United States Supreme Court reaching out to allow executions to proceed, what we're going to see, I think, is exactly what Carol and Justin were talking about. That the death penalty is going to continue to erode as corroded at the state level, at the county level, but those outliers who want to carry it out are going to be emboldened by the conduct of the appellate courts and the United States Supreme Court. So we'll likely see executions go up, even as the pipe that feeds the death penalty system continues to shut down.
Great, thank you so much. Why don't we, so we've been given the green light to go until 2:30 with our discussion. And I'll just pose a general question to start. We've heard some hesitant predictions, long-term and short-term, about what we're going to see with the death penalty on the local, state, and federal level, depending on where you are in this country. I'm a question posed to all of you, but we'll start with Carol. What, if anything, could realistically change or could realistically happen that could change the short-term prediction that you're making?
Well, I see two things that could push it in each in a different direction. So, one thing is that, I think as a student of the US Supreme Court, you never know what's going to happen with the court. Two of the conservative majority, Clarence Thomas and Samuel Alito, are over 70. They're 73 and 71. Like I said, that's young, but, things happen. And so if we're two votes, two people on the court short of flipping it the other way. And I suppose it's not inconceivable, though I don't think it's likely, that could happen. So if the Supreme Court changed, like, I'm back with my 2016 prediction that with abolition in waiting on the ground, that a court that had a reverse majority might move for a Furman 2. So that's one thing. On the other direction, one thing that we're seeing in a troubling way now is, for the first time in the last couple of years, a strong uptick in the murder rate. And one of the things that we've seen has driven a lot of death penalty developments, both in the states and at the Supreme Court, honestly, has been the murder rate. And, I think one of the preconditions for the tremendous decline that we've seen has been this tremendous decline in the homicide rate in the United States over the last 30 years. And if that were to reverse, and honestly, there's a Nobel Prize out there waiting for the person who can tell us why the murder rate goes up and down like a roller coaster. But if it starts another one of those steep ascents, which it did in the 60s, 70s, and 80s, I think all bets may be off for the tremendous decline that Rob was documenting so well. So those are two things I have my eye on.
Karina, Rob, do you have thoughts on this?
Yeah, I'll come in and say two of the things that I've been thinking of is, one is this Supreme Court's jurisprudence so bad? I mean, Carol's waiting for people to leave by some natural disaster or another, Alito and Thomas. I'm saying they're going, I'm looking at Amy Coney Barrett. I'm wondering if the bloodlust will turn her off. We have some very small indication, maybe it will, from the Alabama case. And then, of course, you see Chief Justice Roberts, who's, it hasn't mattered because, as she said, you can peel one off, but he's got to be worried about his court. And you now have justices saying, no, unless you're intentionally trying to torture someone, that there is no Eighth Amendment prohibition. And of course, nobody's trying to torture anyone. And even if they were, who's going to admit it? So, at some point, it's not just a lackadaisical doctrine. It just doesn't exist anymore. And I just wonder, I guess one question for me is, will the bottom fall out so badly where it's that can't be right? That can't be the right answer, because then you just would not have an Eighth Amendment in the context where, frankly, the original intent was about executions. And so to not really have a doctrine in the context of executions, it might strike at least the least of the unreasonable justices as a bridge too far. So that's one thing that I think about. The other is, what happens when you can't get lethal injection, right? And you move to more primitive methods. or other untested methods. So we know now we've got, new gas chambers being built, and I'm going, ooh, it was based on a report from 2 political scientists. Like, you don't have medical, expertise coming in here, and you can't. So that's why they're making it up. And so I sit there and think, one thing that could change the trajectory. What do we think about executions by the electric chair? Again, those were really gruesome. What are we going to think? I mean, how is this going to go with gas chambers and the firing squad, which I think is probably the most humane death, but it's certainly the most explicit. And so I just sort of wonder, I do think there's a segment of the population that's like, more blood, they deserve it. Lethal injections too good for these people. But I think that's not where most people are. And so I do wonder, will that turn off people to the death penalty? Will that be an added thing that comes in? And it's still on the horizon, so who knows?
And I think that one of the big things that will determine the future is what happens with reform prosecutors. If the murder rates are going up, they're going up a lot in the cities. And these are the cities that are electing reform prosecutors who believe that that extreme punishments are not appropriate. I think that will dampen the effect of the increased murder rates only if reform prosecutors are able to stay in office. And we're also seeing a kind of Empire Strikes Back response to the reform prosecutors as state officials are trying to interfere with their local autonomy. And I think that's part of the larger national movement we're seeing about interference with democratic institutions and allowing votes to really mean what they mean only when the voters agree with you. So I think that's an important factor. There's always the possibility of expanding the Supreme Court in size. I think that's unlikely to happen. And because of that, it took Justice Kennedy a long time to get on the cusp of voting to abolish the death penalty. If there are minds that are open on the right wing of the court, it'll be a while before that takes hold. So I think it's going to be a continuation of corrosion and erosion. One by one, states will abolish. One by one, counties will pursue it less. And then it's exactly what Carol and Jordan said. It is abolition in waiting.
Now, one question that's been on my mind is we've seen recently these wild swings in death penalty practices from the federal executive branch with the change in administration, pretty much from one extreme to another, it appears. And I'm wondering what you all think as to how much does that matter? How much does it matter what the federal justice system is doing when it comes to the state's behaviors, the Supreme Court's assessment, and the public opinion on the death penalty?
What the federal government does matters. I mean, it's big. And it is symbolic. It is what the rest of the world thinks that we're doing. I think that we actually are not at an extreme with Joe Biden, even though he said that he wants to try to end the federal death penalty. I think he has no policy on the death penalty. He has allowed the Justice Department to do that. And the Justice Department is trying to fix the federal death penalty. They haven't taken steps to try to end it. He can end it by commuting death row. It'll be interesting to see if that's what happens. But there's important moral leadership. And also, I just got a report a week or so ago that there are medical shortages of some of the drugs like potassium chloride, which is the killing drug. There are hospitals that don't have the supply of injectable potassium chloride. And so you could see federal regulation saying that you can only use these drugs for medical purposes because of this medical emergency. There are lots of steps the federal government could be taking that would provide incentives for states to reduce the death penalty. And I don't think they're doing it right now.
Carol, you started us off. Would you like to get in the last word? And we have a couple of minutes left.
Well, I'll say one last thing about sort of picking up on what Rob said. I do think the Biden administration has been disappointing in the way that it hasn't moved, forward with the promises of candidate Biden about the death penalty in any hurry. But I do want to end in a hopeful note, which is that the election of Joe Biden was the first time in American history that I'm aware that we have elected a president who campaigned very directly on opposition to the death penalty. That's a first, and I'm hoping that that is a sign of what we will continue to see on the ground. And I think Rob and I are linking arms in solidarity and predicting a continuation along those lines. I'll stop there. Thank you so much, Megan.
Thank you, Karina, Rob, Carol. That was just spectacular. Claire, we will pass it back to you.
Thank you all for sharing. Chris, the rest of the journal, and I all appreciate you taking the time out of your busy schedules to be here with us today.